This is the November meeting of the Southampton Village Planning Board. We have a motion to open the meeting.
I will move that we open the meeting, the regular monthly meeting for November the 2nd, 2020 of the Planning Board of the Village of Southampton.
Somebody want to second that?
Second.
All in favor?
Aye.
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 Kathy, would you share your screen with the agenda?
All right, can you all see that?
First item on the agenda is an extension request, which the applicant has requested an extension of consideration of their extension request till December 5th, 2020. Is that correct, Kathy?
Yep, that's right.
They don't want an extension to December 5th. They want to not have it considered until December 5th.
No, yeah, they're just asking to extend the approval through December 5th.
But it's already November 5th, 2nd. So they only need 30 days extension?
Yeah, I guess so.
Okay, so in other words, we could vote on that now to grant them the extension to December 5th.
Yes.
All right.
Well, if it requires a motion, I'll make the motion that we're giving them another month to the next regular meeting.
Somebody want to second that?
Second it.
All in favor?
Aye.
Aye.
I
Aye.
believe that was 5 ayes, Antoinette. So that's extended until the December 5th meeting. We now move into the public hearing. Now, this is, I don't think we've had public hearing. And if we have, maybe I'll just go over with the folks who have, who are waiting online in the Zoom watching this. Typically, the way the public hearing goes is the applicant makes their presentation. Board may ask the applicant some questions regarding their presentation, and then the floor is open to those in the public who would like to make a comment about the application. So we'll follow that order of speaking. Once the floor is open, anybody watching who wants to make a statement, I believe there's a way on Zoom to raise your hand. Is that correct, Antoinette?
Yes, and we do have Gil here, and I can promote him for this application when you're ready.
So just once Gil is done and once we finish asking Gil questions, anyone in the audience who wants to ask anything about the Robinson application, just raise your hand and we'll hear what you have to say. Thank you. So Gil, the floor is yours.
Okay, Gil, I just need you to put your camera on and unmute yourself. There we go.
Okay, can everybody hear me?
Yes. Can't see you, but can hear you.
Can you hear me?
Mr. Chairman, we should probably just say that we did receive the affidavits of posting on this.
Regarding the affidavits opposing to make this legitimately a public hearing.
Correct.
We have received the affidavits of posting for this public hearing.
Correct.
Alice, should they open the public hearing though? Did they do that?
We should make a motion to open it.
Oh, okay, I'll make a motion that we open the public hearing on the Robinson application on Old Town Road.
Second.
All in favor?
Aye. Aye.
Aye. If you're affirmative, Roy, then the ayes have it.
Ayes have it. All right, Gil, are you there?
I am. Can you hear me?
Yes.
Yes.
Okay, I'll try to make this as brief as possible. You know, this is an application that's been around for some time and actually started about 10 years ago. For the information of the public, it's a proposed 2-lot subdivision of property located on the corner of Old Town Road and Herrick Road in the R12.5 zoning district. Both lots actually exceed the R 12.5 size requirements, lot 1 being 14,737 square feet, and lot 2 being 16,433 square feet. As the record indicates, and as I submitted in my letter of September 17th, this project received variances from the Board of Appeals on December 17th, 2009. And subsequently, this board granted sketch plan approval, and a negative declaration was rendered in 2010. Actually, looks like in January, February of 2010. Then in March of 2011, we submitted an application for final approval, paid the fee and so forth, and also had filed with the Suffolk County Department of Health Services. Now, what happened was that the Health Department required a Board of Review hearing, the results of which I mentioned in my letter. And what it did was to require, in order to grant its approval, that we sterilize certain other property within the same groundwater management contributing area to the subject property. And that took us a number of months, if not years, to achieve. In fact, we were able to acquire and then sterilize some property in the Hillcrest area. And I believe Kathy Eisman has a map that can show where an aerial photograph that shows where that property is located. If you're familiar with that area, it's adjacent to and across the street from the King's Chapel Church of God in Christ. And you can see that the property that was sterilized outlined in blue, which is on the south side of Hillcrest Avenue. This was determined by the Health Department to be part of the same groundwater management contributing area as the subject property, and we therefore satisfied the conditions of the Health Department approval. There were covenants filed with that property that it cannot be developed, cannot be used for any purpose which would result in the use of water supply. That took quite a bit of time. I can tell you when we actually did that. A deed was effectively recorded and some covenants and restrictions were filed with the Suffolk County Clerk's office for the latter part of last year. And as a result of that, it was in February of this year that the Health Department finally issued its approval as per the map, which I submitted on September 17th. That enabled us then to move forward, but as you can appreciate, we got the maps toward the end of February, and before we could get the surveyor to prepare the final plat maps, things got locked down because of the COVID-19 situation, and it took us some time to get those maps prepared. Hence, we filed the application, or to reactivate the application for final approval in September. And so that's where we are. I can tell you that the plan that you have in front of you is exactly the same subdivision plan that you previously gave sketch plan approval to. It's the same plan that the Board of Appeals granted the variance for. It was only one variance, by the way, which was a lot variance for proposed parcel 1. The only change that has happened since this all started is that, as you may recall, the requirements for lot minimum and total side yards were based on lot width. The result of that was that there's a slightly larger building envelope for parcel 1 than there was even when this was approved. So nothing was taken away from it. Nothing that has happened since you approved the sketch plan has affected the subdivision whatsoever. As you know, back about 10 years ago, there was quite a bit of discussion with the community about it. In fact, I believe at the Board of Review hearing, even some of the community members were present. But the conclusion on the part of the village and on the part of the Health Department was that this was a project that was suitable for approval and that it ultimately met all the requirements for the subdivision. I know there was some question early on about the effect of the division on the loss of parking spaces on the south side of Herrick Road. But as you know, subsequent to that time, this whole area where the property fronts on Old Town on Herrick Road is a no parking zone in any event. So no off-street parking spaces would be lost as a result of one additional curb cut on that property. And I might also mention that because this is a corner lot, even if it weren't divided, we would have the right to another curb cut on Herrick Road in any event. So I think that's, in a nutshell, that's what it's all about. The reason for the delay in coming back to you was strictly that of dealing with the health department, with which I'm sure many of you are familiar. So if you have any questions, I'll be happy to try to answer them.
Thank you, Mr. Flanagan. Anybody else?
Chairman, I have no questions.
Lisa?
I have no questions.
Does anyone in the audience, Antoinette, have their hand up to speak?
You're up. A hand just went up. Yes, so Linda Kurtz. Let me move her over. 1 second. Okay, Linda, just your screen on, please, and your microphone unmuted.
Can you hear me?
Ann,
I can hear you. Yep, there we go.
Hi there. Good evening, everyone. My husband and I reside at 285 Old Town Road. And first, I would like to request to adjourn the public hearing due to COVID. We never received the notification from Mr. Flanders because, Flanagan, I'm sorry, because there must have, due to the mail, not forwarded to our 285 Old Town address as we're residing here currently due to COVID. So we haven't had an opportunity to speak to council about this subdivision. I know it's been long in the making, hearing from Mr. Flanagan now, but we are new to this. In addition, our neighbors are in England and likely have no notice of this hearing because they have been unable to come to Southampton due to COVID. Thirdly, there is a new village board of trustees, and I believe that the platform that they ran on is against overmassing. And I think this property speaks exactly to that issue. If lots of this size were all permitted to subdivide, the population of our village would look very different. And again, most importantly, neither myself or my husband have had any opportunity to really review this, having just got these documents by chance this past weekend. So I ask that this hearing and the vote for approval be adjourned so that I can reach out to people in the neighborhood whose property will be affected to make sure they have their voices heard and somehow get a hold of my neighbor, both neighbors whose properties abut Mr. Robinson's property and Mrs. Robinson's property.
thank you, Ms. Kurtz. Appreciate your concerns. The issue here, I believe, is that this site plan has already been approved back in 2000, several years ago. So my question for you, Alice, if I can put you on the spot, is in review, since the application has not changed in any material way, and since the village ordinances have not changed in any material way, what options are available to the board? It would seem to me that it would be, having already been approved, our options are limited.
Exactly. Very, very little can happen in this final stage, and no significant map changes can occur. The subdivision is code compliant. Mr. Flanagan and his clients have met their burden under the code already. They've done their noticing under code. That being said, if it's not terribly prejudicial, the board may want to consider holding the record of the public hearing open for a very brief period for written commentary.
Mhm.
I would, may I interject? I'd like to also mention that it's been reported in the papers that the changes to the in 2005 to the zoning were, some people claim that they were not done with due notice. So I would say that even though this board has approved this subdivision change, that there has been the issue raised that those zoning changes that were passed in 2005 are going to soon be under review.
We operate on hypotheticals, and if that were the case, every decision we would be making would be, we couldn't make any decisions until we saw some changes there. So I think we got to operate under the laws as they're currently construed, because anything might happen down the road. Who
I
knows?
understand, but this is for a subdivision of a property less than 1 acre. And I think that this isn't a simple variance. This is a significant change in the way property is being
The lots
used.
are still larger than the zoning requirement for this area. They're 12.5 zoned, and they're larger than that. So in the village plan, these lots of size application, I believe, was approved back when it was. I understand that there's some people who feel like that shouldn't happen, but again, this board needs to deal with the law as it's written.
So is it the board's view that everybody who has more than 12,500 square feet should be able to subdivide? Because we could really increase materially the population by just finding the bare minimum and saying there's just enough room to comply with it. And then should 2 acre lots be subdivided, 4 times, 8 times?
The planning board does not write the laws of the village. It's the planning board's job to review applications presented to it and to either approve or deny them or without conditions.
Right, so your position is anybody who wants to subdivide, so long as they can demonstrate the requirements, the whole village can be broken up into tiny little lots?
No, if they meet, I believe the question is, does it meet the law that we all have until the changes of zoning? This meets the zoning. So if that was what was decided 10 or 12 years ago, we're
Yes, but
bound
I
by it.
understand that Mr. Robinson was on the Board of Trustees at the time, and this raises concern of, I mean, we went through the ARB process, the planning board process, and making very, very simple changes, and neighbors have come to us, and when we were at 50 Fox Hollow, and very simple changes met with vigorous approval process. And I find this to be actually astounding that you would even, that you considered doing this. And it sounds like we weren't there back 10 years ago, but that it meant with considerable opposition. So perhaps now is the time to hit pause and allow the Robinson neighbors to make sure, especially in time of COVID, that we can really review this, speak to our attorneys and our neighbors on this matter, because I think this is a unique circumstance where you're going to approve a subdivision in the village, especially where we just had a new Board of Trustees appointed.
And it's a little difficult to understand the prejudice to allowing for the development of a complete record with respect to an application that's been around since 2009 and now is being raised again during COVID times, where there's been some question as to whether the affected neighbors have gotten notice and been able to respond accordingly. I don't know what the rush has to be here.
I'm concerned about the notice situation, but as I pointed out, this application already has been approved. I was on the board at that time and it was a very contentious application. But the fact is it was approved at that point. I don't recall the vote, whether it was, I think it was 3-2, but I can't recall. It was a while ago.
It was 3-2. It was September 7th, 2010.
So it was contentious, but it was approved. So it's not possible at this time to rehash all of the issues back then. As I asked Ms. Cooley, our legal counsel, the board does not have many options in terms of reviewing the application once it has already been approved. Now,
Hold on. So you're saying that as a matter of your authorities, you lack the discretion and powers to consider whether or not to approve this based on whatever happened in 2009? That seems.
we're not considering whether or not to approve it. It has already been approved.
Well, what is it that you're being asked to finalize today? You're being asked to take action. What's the action that you're asked to take, and why does that action have to take place now?
The applicant, the process is that there is a site plan review, then the applicant goes and gets all the health department approvals and everything, and then their final approval is then given. And if anything has changed materially, that would be an opportunity to then question the application. But again, has been pointed, there is no material change. It's the same application as was approved. And if we were to raise objections to it, the applicant would, I believe, Alice, again, correct me if I'm wrong, have a strong legal case that we would not be able to support a negative decision once the application's already been approved and there's no changes to it.
I agree with that.
Well, except you could have a more complete record. And what diligence has the board done on the representations that have been made with respect to the remedial action taken on whatever that was, sanitizing properties? Has that just been accepted based on what was said today, or has anybody studied that, gotten opinions on it, and confirmed that that condition's in fact been satisfied?
Kathy?
I could speak to that if you'd like. I mean, the Board of Review has issued a determination and they have their health department approval. The health department takes this very seriously, and they look at the property, they make sure that it has not been developed, and they make sure that there's a covenant in place that it will never be developed. So that transfer density has occurred. And the map that I have up here isn't signed, but we have a copy that has been signed by the health department saying, yes, this is approved by the health department. And that's the agency that looks at the groundwater issues with respect to sanitary density.
Well, as I started off saying, we are only now, due to COVID, receiving notice of this significant change in the neighborhood. And I know that my neighbors are in England and were unable to attend their summer home, which they do every year. And I'm sure, very unlikely, that they have had notice of this hearing. And I think due to COVID, you're talking about something that has been going on for 10 years now. This is inappropriate to file for this, not at a true public hearing. Myself, I had to beg to get on, and luckily I met with really helpful village employees that were able to get me on late. I didn't know that there was a 12 p.m. deadline, but I think that it's probably more than likely that other people having notice of this type of change. And I think at the very least, we should be afforded the time to speak to our lawyers and to review what happened for this application, especially where you say, Chairman, that it was contentious and,
Not only was it contentious, I was one of the people who voted against it. So trust me, I'm not trying to push this through. I'm only saying what I'm saying because that's what the law is.
Right, and I get that, but other people would like to make sure that they've gotten advice on what the law is, and I'm sure there's been circumstances where people have come up with something and the information has been material, and maybe there's more opportunities here than you know, based on advice. I don't see any prejudice to leaving the record open. If you're right, if your counsel's right, there's nothing that can be done. Your discretion is somehow blocked up based on what you did before and based on the approvals that have been achieved through health, then you'll be where you'll be. But I can't see that there's any prejudice to allow some of the neighbors to consider their rights and to bring to your attention any relevant authority that might allow you to reconsider something on a full record. And so at least at a minimum, we ask that this be held open so that further materials can be submitted if appropriate.
Roy? Roy?
I believe the applicants then noticed.
Roy, can you hear me? This is Alan. I'm listening with an eye to the fact that what we've been asked for, if you ignore the argumentative comments that anyone wishes to make about something that is this old and has been this thoroughly done for so long with extraordinary notice, public and private, we're being asked to use our discretion under a property subdivision in light of COVID as an intervening event to grant, and I'm listening to our wise counsel to say we're being asked to grant that it's material because of COVID, probably nothing else given all the constraints that have preceded all this with everyone involved. Because of COVID, it is material intervention that we might do something. The suggestion was obtain, and this is unfair to the applicants and anyone who has other views, but we might obtain written submission in time for the next meeting of anything that is material with respect to this application that requires review under all the items that were cited probably 12 years ago, 10 years ago, and so forth. The fact that there was opposition, we've got a lot of those going on right now. This happens all the time. This is why we have boards. This is why the rules are reviewed. We can't argue the merits. It's already been decided by a prior board. But if that would probably be the only thing I would support, written material given with plenty of notice, not at the last minute, plenty of notice of anything that is materially involved that requires this continued public hearing to be continued. If not, I think it is our duty legally with everything that's come before it to approve it as it is. If we could even do a contingent approval right now like we did before for the water department and say it is approved unless in our judgment something material has come up which requires.
I wouldn't recommend.
And the rest of the stuff that's been cited is unfortunately legally irrelevant to us or anyone who sits on this board. And if the applicants are really upset, I guess they could bring writs of mandamus to the trustees to remove everybody who's on the board. There are all sorts of things you can do if you're upset, but that's not before us. It's not fair to anybody. So that's the only thing I could go along with.
I find it sort of remarkable to suggest that the COVID is some minor matter that's not somehow relevant to notice to people who are affected and an opportunity to comment. And nor do I think it's appropriate to sort of decide that people can file special proceedings and seek writs of mandamus to remove all the board members rather than simply to leave the record open and allow it to be developed so that the board can consider all the facts and all the impacted parties. Seems pretty extreme to me.
I believe earlier in this meeting, we offered to leave.
Mr. Chairman, may I be heard? Mr. Chairman, I'd like to be heard on a couple of matters if I could.
Could I hear what Mr. Piazza say?
I believe that earlier in this meeting, we offered to leave the public part of this matter open for a couple of weeks for written comment, didn't we?
Well, we've considered
that suggestion.
Yes. I don't want that to go unheard.
Right. No, that's great, but I haven't heard it get adopted, but I did hear that that was a possibility.
Mr. Chairman,
It's
could you
very
hear
much
me?
a possibility.
I don't think you hear me.
Recognize Mr. Flanagan.
Yeah, no, I've listened to what's been said. Maybe I didn't mention it before, but when it came before the Board of Zoning Appeals a number of years ago, some of the neighbors did challenge that decision, and their challenge was overturned by the State Supreme Court in Riverhead. So not only has there been considerable public input to this application, but it's already been judicially reviewed and found to be proper. As has been pointed out, there is no change in this subdivision since it was approved by you and by the Board of Appeals, and it now has the Health Department approval. I really think there's no choice in the matter but to proceed apace with this application. I would not be in favor of keeping the matter open, especially for all purposes, and I would not even for written submissions only. I think the case speaks for itself, and I would request that the matter be held, the public hearing be closed.
Thank you, Mr. Flanagan. Jane, Lisa?
I'd like to know, for clarification, why did this come to a public hearing again if it was already approved?
That's only because the way the code is written, we have to show that we've met the final requirements, which in this case was that of the Health Department, which we've now done.
Okay, it just seems very difficult that this started so long ago. I understand bureaucracy takes a long time very often, but it just seems, I respect what the Kurzes are saying about this is a very different time than it was 10 years ago, but I see your side also, Gil. This was a said and done deal. It puts us in an awful predicament when the public is asking to be heard and we're basically saying, well, law says no.
The fact of the matter is, though, nothing has changed with the law since this application was approved, except for the minimum and total side yard setbacks, which in this case actually were advantageous to one of the lots. So nothing legally has changed. And the fact that there may be a new board of trustees that may have things that they want to do about cutting down development, that's a legislative matter. The fact of the matter is that this property in this area is zoned for this use, and not to approve it would be, I would think, would be extremely arbitrary and capricious.
Mr. Chairman, I think we should move toward a vote.
The question is whether we want to consider this and advise our council to perhaps hold this over for another 30 days and invite any of those who feel they have the opportunity to speak because of COVID difficulties in notification, make their feelings known. Even given the fact that unless something material comes to light, it has no authority to turn the previous approval. Is that where we're at?
Yep.
Is there a chance that that could be done conditionally?
Conditional on what, Tony?
If we vote tonight with the condition that if anything material surfaces.
Well, I would.
That's it.
Motion should be to hold over, to adjourn for 30 days. Let's just vote on that motion to adjourn for 30 days, during which time we will entertain written commentary on this application from anybody who was noticed, but did not feel they had the opportunity to come to this meeting because of where they are located or because they had difficulty getting notice.
Yep.
Correct.
Yeah, I would strenuously object to that, given all the circumstances and given the fact there's been no change in the law.
And I'm not sure what the prejudice is of this, that effort to get this done without hearing members of the public sounds concerning. I don't understand. It's not as if some permit or license is about to lapse or there's any urgency whatsoever, especially on a 10-year project here. It seems perfectly appropriate to allow 30 days. It means nothing to anyone except the impacted public that wants to be heard. And presumably the board that would probably want to get all the facts.
If this board should decide to adjourn it, and I'm not saying by any means I agree with it. In fact, I oppose that concept, but if it is, I would strongly, respectfully request that it be for written submissions only.
I think that's appropriate.
I agree.
So let's see what the board thinks. Put together a motion. Alan, do you think you can put together a motion?
Yeah, I'll try. Let me give it a try. I will make the motion before the board that this public hearing will be final as of the 5th of December, unless at that meeting, when we ratify that it's final, we have received, in the opinion of the board, with advice of our counsel, written submission, at least, I'm thinking about Thanksgiving, at least by the 23rd of this month, because it needs to be prompt, because we got a Thanksgiving holiday coming up. By the 23rd, we have received written submission of something material that calls for a public hearing to be reinstated. That'd be my motion. We approve that if we receive in writing from, and I guess we have to ask the applicant to review, given the COVID situation that affects us all, to make sure that notice under our current laws, which again, everything's changing in that regard, period. But the written submission under our COVID laws has been given to relevant parties under the requirements of the village statutes. So subject to the notice being given to them, again, we get written submission by I'm picking the 23rd. Somebody else can pick another date of something material that would allow us not to confirm this application without any further hearing.
Mr. Chairman, if I might make one observation, if there are submissions, I think the applicant should be given an opportunity to review them and respond. Maybe we could establish a schedule for that. I think that would be appropriate.
I think that's a good idea.
I agree. That's why I was trying to pick a date.
And that let's say we would have a week after whatever that date is to respond. And I also would point out that the notices were sent out by mail and the property was posted all in accordance with your code requirements.
That was noted. Thank you.
Thank you. I assumed Mr. Flanagan, after a long experience, that would be the case, but I just now, in light of the intervention of what the guys used to call force majeure or something like that, we are going to make doubly sure that it's been effective under COVID.
Well, you have an affidavit of mailing that stands for that proposition, just so you know.
No, thank you.
Somebody want to second Mr. McFarland's motion?
I don't think we have established the schedule yet, and I think we should do that.
Or wouldn't you want to actually have the motion approved? We have a schedule established?
Well, the motion should have the schedule, I think, Roy. That's why I picked the 23rd, to give time before the 5th for the applicant to deal with anything that may arise, and the other people to catch up with a decent time. That's what, 20 days? And 10 days after, that's about 30.
So our next public meeting is December 7th. So we're giving the neighbors until November 23rd to submit their opposition, and then Mr. Flanagan needs at least a week, I imagine.
Gets us to our work session, which is on the 30th. We won't have time to review it.
But we will have time to review it before our next public meeting.
Yes. So Alice, can you just clarify, are we actually closing the public hearing subject to written comment? Or would the public hearing actually be closed then officially on the 7th?
We'll close it for all purposes on the 7th, and we'll close tonight's public hearing.
Okay, so for secra, we have, we looked at doing an updated negative declaration. I guess that can be held off also until the 7th.
I think we should vote on it tonight. There's
Okay.
nothing there.
Yeah, it's just reiterating everything that had been hashed out in 2010.
That's, I think the secret thing would depend a lot on whether something material comes in.
Am I carrying on or do you want to just call?
Part of the secret thing is whether the subdivision, it has a lot to do with changing the character of the neighborhood. Now, whether or not the secret thing was already approved, and you're saying that it hasn't material changed, but there has been several years in between the time of the original secret determination and now, and community standards, everything has changed in those 9 years. So I would say the secret determination could depend on what the material, what the written commentary is.
I respectfully disagree. I don't see how community standard would change this negative declaration.
I certainly would support that position.
There are many factors to speak of, Alice, besides there's character of the neighborhood, there's safety, there's many factors.
Mr. Chairman, nothing has changed in those regards since you approved that original negative declaration.
I mean, we looked at land, water, transportation. I don't see how that changed.
There were specific things that you look at when you're rendering a negative declaration. As you know, when you fill out those forms, there were specific categories that you look at. And I would submit to you that nothing has changed in those categories since you adopted your previous negative declaration.
Yeah, we haven't had an opportunity to dig into any of this, but there's obviously been a lot of build in the last 10 years. I don't know whether any of that new build has an impact on the character of the neighborhood and the capacity, but I mean, these are the kinds of things that we'd like to at least consider with the help of council and some of the neighbors here.
And the secret approval relative to the public hearing, Kathy?
Just legally that before the public hearing is closed, it needs to be adopted.
Okay. Well, we're back to sort of a motion floating around.
I would submit you, if you're going to proceed in this fashion, you could close it. You should keep it open for, keep it open for written submissions only.
Well, we have an opportunity to be heard. I don't understand why it's a problem for neighbors and people in the community who are members of the village, residents of the village, to have an opportunity to, as my husband said, review these documents, get up to speed, and also to submit written, any written opposition, and then to be part of the hearing, the public hearing, I guess on 12/7/2020.
And it's not as if this moves things along or provides any speed or other benefit. It's just an effort to limit the ability to raise concerns. I think the board should maintain its ability to address any issue that's appropriate to address when the time comes. I mean, I understand Mr. Flanagan's got a client here and he's got an interest, but I don't see why there's anything to be gained by having some limitation on what can be presented. The board's going to have an opportunity to rule on the 7th, and I don't see why the board should be restricted in any way in what it's able to consider at that time.
There's a motion that we need to kind of clarify and clean up, which would allow for written commentary until the 23rd of November. And then the board will consider what is printed forward at the session, at the next regular scheduled meeting on December 7th. So I think what should happen is that motion is on the table, somebody should either second it, or else we should decide that we're going to close the meeting tonight. I mean, those seem to be the two options that we have before us.
I'll second it.
Well, Antoinette,
We need to clarify
we need to call-
by what date Mr. Flanagan.
Alice, you're breaking up, sorry.
We need to clarify the date by which Mr. Flanagan.
So we need to clarify the date by which Gail Flanagan needs to provide a response to this board.
Okay, so, yeah. The neighbors, the notice neighbors would need to respond in writing by the 23rd of November. The applicant would need to respond with their written responses to those objections by, Gil, how much time do you need?
At least a week, I would think.
So what's that put it to,
That'll
December,
put The
The
30th.
30th.
say again, the 30th?
Yes.
Yeah, I guess that's the date of your work session.
Yeah, I
Yeah.
wouldn't want it to be after that because we want to talk about it at the work session.
Okay,
Okay with me.
what are the two dates?
And then we can vote on the 7th.
And then we would consider both sides of the argument that is presented to us by the applicant and the neighbors, and then we would vote on the 7th. And at that time, do the SEQA determination as well.
That's what, those amendments to my motion, I think clarify the motion.
So is there a second to that motion?
I'll second it.
I second.
So Antoinette, I think you both need to call the roll on that vote.
I would like to. I just have one question. The hearing is then adjourned, correct? Not closed?
Correct.
Okay. Chair, how do you vote?
I vote aye.
Mr. McFarland, how do you vote?
Aye.
Mrs. Claire? Mr. Piazza?
Aye.
And Ms. Cowell?
Aye.
Motion passed. So, Linda, and the Kurtzes, we will hear from you and anybody else that you want to advise to send us written notification of their concerns by November 23rd. And we will get those objections to Mr. Flanagan, and he needs to respond by December 3rd. They will consider both sides of the argument at our work session and vote on it on our next scheduled meeting in December 7th. Okay, everybody? All right.
Thank you, Chairman.
Thank you.
No, it's just, we don't need to adjourn this application, this public hearing. This for the Robinsons, do we? Is that took care of that or not?
I didn't hear that.
We need to now adjourn this for this evening, or did that motion take care of it until that?
We did that. We did that.
So next public hearing is 54 North Main Street. The North Main LLC is the applicant here.
I don't have a hand up and I'm not, oh, here we go. Got it. Hold on one second. It's Kyle Collins and I will let him in.
We should have a motion to open, and we also did receive the affidavits of notice and posting on this application.
Kyle, I just need to put your camera on, please. Oh, there you go.
I'll make note that we received the affidavit of notification for 54 North Main Street. And somebody like to make a motion to open the public hearing.
So moved.
All in favor?
Aye.
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 It's unanimous. Please state your name and address. And
Sure. Kyle Collins, KPC Planning Services, 16 Library Avenue, West Hampton Beach. Here on behalf of the applicant, North Main Street LLC. The subject of this sketch plan application is located at 54 North Main Street. The site is approximately 72,740 square feet, currently developed with a 5,384 square feet, one-story multi-tenant office building in the front of the lot, and a 2,400 square feet workshop associated with a special trade contractor use in the rear of the site. Subject site is split zone between the R20 in the front, which requires a minimum of 20,000 square feet. And the rear of the site is located in the R7.5 zoning district, which requires a minimum lot area of 7,500 square feet, excuse me. The two existing uses are non-conforming. The office, multi-tenant office building, as well as the special trade contractor use, as well as the existing buildings are non-conforming as they don't meet the current setbacks. The proposal is to subdivide the subject parcel into two lots, the rear lot being 40,000 square feet, and the front lot would be 32,742. The application was presented with two alternatives. I'll focus more on the flag lot alternative, given that the planning board at their work session seemed to prefer that alternative, and the applicant does not have a problem with providing that alternative. Again, the 40,000 square foot lot would be access to North Main Street via 15-foot wide flagpole. It's actually 18-foot wide flagpole, and the minimum width of the pavement providing access to that rear lot would be 15 feet. The existing curb cut would not change. There's actually two curb cuts onto North Main Street. The proposal that the southerly curb cut would provide access to the rear lot. The proposal is to eliminate the one pre-existing non-conforming use, that being the special trade contractor use and the wood shop that is associated with that use in the rear of the site, and it would be developed with a single family home. I don't know, Kathy, can you put up the neighborhood map? I'm not sure if you have that
Yeah,
available.
I think is it in this that
Yeah,
you submitted?
it should be. There it is.
Okay, it's a different, of course, we got north in the other direction now, but
North is actually in the bottom of the page, east being to the left, and west being to the right. The character of the neighborhood is single family surrounding the entire site. As you can see, as indicated on the parcel, there's a range in lot size going from the smallest is a 9,600 square foot parcel, which is to the southeast corner of the site, and up to a 39,800 square foot, which is a flag lot just on the north side of that site. So the parcels that are being proposed, particularly the one that's going to be redeveloped, the elimination of the non-conforming use, it's going to be 40,000 square feet, substantially larger than the minimum lot size in the R7.1 zoning district, as well as larger than the existing developed residential parcels that surround the subject lot. That's basically a rundown. I did do, and just to put it into context, did submit a yield map if the entire parcel was redeveloped, that being eliminating the office building use and the special trade contractor use in the rear. You would get the minimum square foot of a 20,000 square foot lot in the front, and 3 parcels meeting the R7.1 zoning district requirements. I just put that into context. This is not what we're asking for, and it's just see what the as of right subdivision under the village zoning is. And with that, I'll open it up for questions from the board.
Thank you.
Kyle, I have one question. Did you, the one-story office building on lot 2 would stay as it is?
That's correct.
Okay.
Yeah, Tony, I agree. I'd like Mr. Carl to take that one out too and build a lovely house there. That would be nice.
That would be really nice.
But that's not in front of us. As long as it's a flag lot, it seems to me, my view is that this is meets all the requirements that are regularly before us, and that particularly when you look through behind the neighborhood behind it, which is filled with its own set of issues. I think that just to the north is that home that's up there on Layton. So I think this is an improvement to the neighborhood.
Don't have any questions. Jane, Lisa?
Anyone for the public hearing to speak, or is that it?
If Jane or Lisa do not have any questions, is there anyone in the public with their hand up?
There is not.
All right. Well, I think it looks good. So did we want to close the public hearing?
I'll make a motion that we vote to close the public hearing.
Kathy, we don't need any secret on this. I think we've done that, haven't we? Or
Yeah, we did the secret.
Yep.
Previously.
always good to close the meeting? All right, does we have a second for Mr. McFarland's motion?
I second.
Antoinette?
Sorry, I was typing. Yes, Ms. Cowell, how do you vote? Ms. Cowell?
Aye.
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 Ms. Claire, how do you vote? Ms. Claire, how do you vote?
Aye.
Sorry. Mr. Piazza, how do you vote?
Aye.
Chair? Chair, how do you vote?
Aye.
And Mr. McFarland, how do you vote?
Aye.
Okay, thank you. That public hearing is closed. And we will prepare this application for decision.
Excellent. Thank you very much, board.
Thank you.
Thanks, Kyle.
Decision section 99 Sanford Place LLC. Any additional info? Kathy, can you bring us up? to
Yeah, and so we had a plan that was submitted that had been reviewed by the fire marshal. Today, I guess it was submitted to the village and a copy was emailed to me. This is basically the same as what we've been looking at. They removed, I guess there was a note about a gate previously, but that is no longer there. And it shows the proposed new pavement that would allow a fire truck to back in and out of the site and provide emergency services. The building inspector has weighed in that this no longer, this is eligible for the relief that was provided in 1988 for the lot width. So they don't have to go to the Zoning Board of Appeals for the lot width. And so they have submitted, I think it's 46 pages last week that I haven't gotten my way through, but maybe we can hear from the applicant if there's anything that they wanted to add. But at this point, we're going to make our way through the submission and see that it's addressed all the comments from our prior report. So maybe if you could see if somebody's here from.
I have a Liz Vale. Would that be for the applicant?
Yep, that's Liz.
Yeah.
Yep.
Okay, Liz, just camera on and unmute yourself, please.
Good evening, board members. Liz Vale, Farrell Fritz, 50 Station Road, Watermill. How are you all? So we did submit something just last Friday. I totally understand the need to have your counsel and Kathy review it. But some of the major points of that memo were that it was in response to Kathy's July 1st, 2020 memo. So some of the issues she had pointed out, we tried to address, which were working with the fire marshal, and we obtained approval from the fire marshal on Friday. He stamped our plan approved. We had to make some additional notes to the original design of the Hammer turnaround there that you can see on the plan that's before you. So we made the notes and we were able to obtain approval. We've just submitted that to the village today. So we're anticipating your review of all of our responses. We were also asked to reach out to the neighbors at 80 and 120 Sanford Place, which we've done. And so far we've received very favorable feedback that they support the project, and in particular, the conversion of this office building subdivided into 2 residential parcels. So that's our initial feedback for the board. We'd ask you to review our memorandum, and we're happy to move forward. If we are respectfully requesting that the board consider setting a public hearing. It's up to you. So, thank you.
If we can get the neighbors to put their kind thoughts in writing, that would be wonderful, rather than just having to take your word for it. Because I do feel the neighbors need to be advised of the situation, but I'm glad that they're on board with it. And Kathy, so we would await your review, analysis review of what's been submitted, and we can go over it at the work session, but assuming.
There's such a long time between meetings, so we were hoping you'd consider setting a public hearing.
So would it be appropriate, Kathy and Alice, assuming there's nothing untoward? And
Yeah, the comments that we had were not on the map, so per se. So as far as a complete application goes, this is a complete application now, so it's appropriate to schedule a public hearing, is in my opinion.
So Liz, you can go ahead and do that, and we'll take a vote on scheduling the public. We need to vote on that, right?
Yeah.
Al?
Yeah.
Yep.
I'll make a motion, Roy, that we schedule the public hearing. And I agree with parenthetically, the comment is to see if any, as you pointed out, neighbors are involved. This is probably all routine, but we have to deal with I think it's the people living on the north side of this street easement, et cetera. So it'd be good to have the public hearing as soon as we can. So I'll make that motion.
So it's December 7th is the public hearing date.
Yep, on that Monday.
Second it.
All in favor?
Aye.
Aye.
Liz, you'll just have to do proper noticing on that, and you're on for public hearing.
Thank you so much, board members.
Thank you.
Welcome.
Have a good night.
Have a good night. Thank you.
Second subdivision is the Community Baptist Church. At 60 Reverend Raymond Lee Court. Kathy, you had this is a new application on the agenda. Kathy, you had some information about that.
Yeah, so actually, the applicant is is present. This is a subdivision that involves a church property and a property that's developed with a residential structure. It's in the light industrial zone, and it actually was 2 lots previously. They're coming in at this point. It's the sketch plan phase of the subdivision. And as far as the sketch plan phase goes, they have a complete application. So it is appropriate on this one as well to schedule a public hearing. But I think that it would be appropriate for the board to hear something from the applicant's attorney, who's I think is here at the meeting.
That'd be great to get what the application entails.
Yeah, and I'm going to stop sharing my screen for a second because I need to bring the map up and I have to find it on my computer.
So
Okay, I'm going to promote, Bailey is here to represent, so I'm going to bring her in. There you go. Bailey, if you could just put your camera on and unmute yourself, that'd be great.
hi, Bailey. Can you hear us?
Hi.
There you are.
Okay. Bailey Larkin with Bennett and Reed, offices at 212 Windmill Lane in Southampton. This is a proposed 2-lot subdivision. The property was actually 2 lots up until about 2013 when the church acquired the property. When they acquired the property, they merged the 2 parcels, and the church had the intention of converting the residence into office space. At this point, that conversion never happened. The church is now looking to transfer that front lot to the Southampton Housing Authority to establish affordable housing in the village. We have been before the Zoning Board of Appeals, and we have received approval for the proposed use and also some dimensional relief for the proposed lots, which are less than 40,000 square feet, which is required in this district. This proposed subdivision would allow for the residents for affordable housing to be located on lot 1, and the church would also get the benefit of a parking easement over that lot. The church currently does not have any designated parking. This would be a non-exclusive easement for use by the church and also for overflow parking for the proposed residents. The lot line would be the exact same lot line that was where it was formerly established. And it's actually shown on the 1981 tax map in this proposed configuration. We do have an application pending with the health department. It has not yet been approved, but this was just submitted with you as a sketch plan for, and we would ask that you schedule a public hearing on this matter.
Yes, to be clear, lot 1 currently is not developed. It has no structures on it.
Lot 1 is currently developed with a single family home. This application would actually be a 3-unit multifamily home that would be proposed.
You just take down the single family and build the multifamily?
Correct.
Okay, thank you. Great. So Kathy, again, tell me that the application is complete. So what are we looking at that needs to be done to consider the application? Nothing? We just need to schedule the public hearing?
We do need to schedule a public hearing. We will need to do the secret review between now and the public hearing. So that way the board can consider a secret determination.
And you'll be able to get that done before the next meeting?
Yes.
Okay, great. All right, does anybody else have any questions?
Sounds good.
All right, well, if you're ready, then let's make a motion to applicant. You're ready for the public hearing to be in a month?
That would be great.
Okay.
Yeah, I'll move that we have a public hearing. Let's get the applicant in there. I think we are probably a board, although we don't plan, that need, particularly with this parking thing we're going to do, to take notice of the growing community need for this housing. So I think given the area and what's there and everything else, this is pretty responsible stuff, is my observation. So I'll make a motion that we schedule a public hearing on this matter for the 7th of December.
Second.
All in favor? Aye.
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 I think everybody voted. Did everybody vote aye?
Yes.
Okay. Motion passes. Lisa, you're on for public hearing of December 7th.
Yes.
Yep.
Krista Alexander.
Okay, moving on.
I'll get back in a minute.
So, Chair, on 7 Powell Avenue, I don't know if Stuart is in the audience, but he did send an email to Jackie Allen today asking that the planning board hold off on additional review at this time. He's working out with PSE&G. He has to relocate a guy wire that's in the way of the proposed access. So that's a change in the access that he was proposing previously across MTA property. He's proposing something different now. But in order to make that happen, he has to get that guy wire relocated. So he asked that we hold off, and so I'm going to interpret that to be that he is requesting an adjournment.
That's more than enough for me.
Okay. I'll make a motion at the request of the applicant to adjourn 7 Powell Avenue LLC.
I'll second it.
All in favor?
Aye.
Aye.
And that would be to the next meeting, and have it at the work session, unless we hear otherwise.
Correct. Thank you. All right. Is there anybody else in the audience, Antoinette, that didn't get to say what they wanted to say?
I have no more hands up.
Okay, great. Well, that concludes the items on the agenda for consideration. We do have minute approvals from. I think everybody's had a chance to look at them. I saw a few changes, grammar and a few wording changes, but I think everybody's probably okay with it. So if somebody wants to make a motion to approve those, you can go ahead with that.
I'll make a motion to approve the minutes of October 26, 2020.
Second.
All in favor?
Aye.
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 Aye. I'll make a motion that we adjourn the meeting, Roy. Thank you.
Just let us know that the next meeting is a work session on November 30th at 5 p.m., also a Zoom session. The next regularly scheduled meeting will be December 7th, 2020 at 5:30 p.m., also a Zoom session. Thank you, Alan. Would somebody want to second the motion to adjourn the meeting?
Second.
All in favor?
Aye.
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 Thanks.
Aye.